Hello, I'm attorney Vince Davis. California's family law landscape is undergoing significant changes between 2025 and 2026. These legislative updates are designed to modernize court procedures, increase transparency, and enhance protections for families. One of the most significant procedural reforms is the expansion of the joint petition for dissolution of marriage under Senate Bill 1427. Traditionally, divorce followed an adversarial model. Now, spouses can file a single joint petition, which automatically constitutes service. This eliminates the need for a process server and the associated 30-day waiting period for a formal response. Eligibility for this streamlined process has expanded to include couples with children and property, provided they agree on all terms in advance. This shift can save couples hundreds of dollars in process server and separate filing fees, reducing the average cost of an uncontested divorce. Remember, if either party changes their mind, the joint status is revoked and the case reverts to the traditional adversarial track. Moving to child custody, the focus is shifting toward child-centered outcomes and long-term stability rather than just parental rights. 2025 updates reinforce a presumption that substantial shared parenting time is generally in the child's best interest. Judges who deny equal parenting time may now be required to provide a detailed written explanation for their deviation. Assembly Bill 3072 now mandates that courts consider a parent's illegal access to firearms when determining immediate harm to a child. This is a critical factor in emergency or ex parte custody hearings, ensuring child safety remains the top priority. Additionally, AB 81 requires strict adherence to the Indian Child Welfare Act from the very first court appearance to preserve cultural integrity. Under SB 599, vague agreements like reasonable visitation are being discouraged in favor of highly specific parenting plans. Orders must now include exact exchange locations, times, and specific communication protocols, such as using co-parenting apps. Let's talk about money. Child and spousal support laws are also being modernized to reflect our current economic reality. The updated child support formula, effective through 2025, adjusts the K factor, the percentage of income allocated to support. The new formula considers a wider range of income, including investments and rental income, to ensure children are properly provided for. Starting in 2025, support for adult disabled children can be directed into a special needs trust under AB 2397. It also provides a low-income adjustment for parents earning up to $2,900 in monthly net income. This ensures the support doesn't disqualify the child from essential public benefits like SSI or Medi-Cal. SB 1055 prevents the state from suspending driver's licenses for child support arrears if the parent is low income. The enforcement threshold for license suspension has also been raised from 30 days to 6 months of unpaid support. In spousal support, California courts are leaning more heavily toward the goal of financial independence for both parties. For marriages under 10 years, courts are strictly applying standards focused on earning potential and a reasonable time to become self-sufficient. Critical new laws are also closing loopholes in domestic violence and safety protection protocols. California now formally recognizes coercive control, including psychological manipulation and isolation, as a basis for restraining orders. AB 2759 requires individuals subject to a domestic violence restraining order to immediately surrender all firearms, with no exceptions. Survivors can now file for restraining orders in any California Superior Court, regardless of where they permanently reside. Under AB 2024, court clerks can no longer deny a restraining order application solely due to minor clerical errors or incomplete forms. Administratively, the Judicial Council is pushing a digital-first approach with expanded e-filing and remote technology. Assembly Bill 170 extends the use of remote technology for certain family law and juvenile proceedings through 2026. Starting in mid-2026, the process for name changes to match gender identity will be simplified by removing the objection process. With so many changes coming to California family law, navigating a divorce requires careful planning and legal expertise. Understanding how these new statutes apply to your specific situation is essential for protecting your future and your family. Whether you are dealing with complex assets, custody disputes, or support calculations, you don't have to face this alone. Staying informed about the latest 2025 and 2026 updates is the first step in ensuring a fair and equitable outcome for your case. Our commitment is to provide you with the clarity and guidance you need during this transition in California family law. To recap, we've covered the new joint petition process, child custody safety inquiries, and support formula adjustments. We also looked at the expansion of domestic violence protections and the move toward more digital and remote court proceedings. Preparation is key to a successful divorce in California under these new rules. Don't leave your family's future to chance. The legal landscape is shifting, but with the right information and professional support, you can navigate it with confidence. Always consult with a qualified family law attorney to understand how these 2025 and 2026 laws impact your specific circumstances. The changes are many, but the goal remains the same: a fair resolution that protects the best interests of you and your children. Thank you for watching this comprehensive update on California divorce laws. Knowledge is power, and we are here to help. Navigating these updates may seem daunting, but with decades of experience, we can guide you every step of the way. Stay tuned for more updates as we continue to track the evolution of family law here in the state of California. Call us now at 888-888-6582. I'm Vince Davis, and we are all in this together.